The English High Court recently made a decision in a case called Avanti Communications that offered some interesting guidance on how the courts may interpret certain important provisions of security documents, in particular in the context of fixed and floating charges. This was an English decision, so not binding on Irish courts, but nonetheless will have persuasive authority. The decision is particularly important because the most common form of security document given by an Irish corporate borrower is the debenture, which typically comprises both fixed security over particular specific assets owned by the borrower and also a floating charge over everything else that the borrower might own from time to time. And that distinction is especially relevant in the context of an insolvent liquidation because a fixed charge holder ranks in priority to the holder of a floating charge and also in priority to certain other creditors such as the revenue commissioners and certain amounts owing to employees. In this instance, the assets in question comprised both physical satellite equipment and also some intangible rights and licenses that Avanti had to use that equipment. The security document purported to create fixed security over all of these assets and also included what's called a negative pledge. That is to say, a provision that restricted Avanti's ability to use those assets during the lifetime of the security. That's the hallmark of a fixed charge. But the negative pledge contained some carve-outs. In particular, Avanti was free to dispose of or sell assets below a certain value threshold, and also any assets that were obsolete or redundant or no longer useful to the business. And the court found that, notwithstanding these caveats, it was still nonetheless a fixed charge over those particular assets. They applied the usual test, which was to look firstly at the intention of the parties at the point in time when they contracted with one another and the labels that they used, the terminology, in this case, a fixed charge. But they also looked at the practical controls, the contractual controls that were in place during the course of the security agreement. And on that basis, they decided that notwithstanding that the company did have some freedom to deal with the assets during the course of the security, it was nonetheless a fixed rather than a floating charge. This case is particularly useful because every security document will contain a negative pledge, but it's also very common to have these forms of carve-outs and caveats from it. So the fact that the court didn't take too restrictive a view, but instead a more nuanced one, will offer reassurance to lenders that a court is likely to look at the combination of factors that apply in a particular case. But overall, this is just one of a number of cases over the years on this particular point of law, each one of which will require careful consideration and its own interpretation.